In a criminal appeal brought by a defendant, generally the following may occur. Within 10 days of filing the notice of appeal, appellant may direct the lower court clerk to include or exclude any documents or exhibits filed in the lower tribunal in the record on appeal, and may designate any trial proceedings that should be transcribed and included in the record on appeal. If appellant directs the clerk to exclude any documents or portions of transcripts, then the appellant must also file a statement of judicial acts to be reviewed. Within 20 days of filing the notice of appeal, appellee may file directions to the court clerk and designations to the court reporter if appellee feels that additional materials are important for the court's consideration. Within 50 days of filing the notice of appeal, the clerk of the lower court will generally prepare and serve the record on appeal. However, the clerk shall not serve the record on appeal until all proceedings designated for transcription have been transcribed by the court reporter and filed with the clerk. If the designated transcripts have not been filed by the date required for service of the record, the clerk shall file and serve a notice of inability to complete the record, listing that the transcripts have not yet been received. However, an order granting an extension to the court reporter to transcribe designated proceedings shall toll the time for the clerk to serve the notice or record on appeal. When transcripts are filed after notice from the clerk shall prepare and file the record within 20 days of receipt of the transcripts. If the defendant is not indigent, then defendant's counsel will not receive a copy of the record on appeal, but just a copy of the index to the record on appeal. Within 30 days of transmission of the record or designation of appointed counsel, whichever is later, the initial brief generally shall be served. Within 30 days after service of the initial brief, the answer brief shall be served. Within 30 days after service of the answer brief, if any, the reply brief shall be served. A reply brief is not required. It's in the appellant's discretion. Both parties have until 15 days after the reply brief is due to be served to request oral argument. Even if you request oral argument, it does not mean it will be granted. It is in the discretion of the appellate court. After the final brief is filed, or if there is oral argument, after the oral argument has been held, it is now up to the appellate court to rule. Once they rule, you will receive an order from the appellate court.